Call on Deputy McNamara.
Thank you, Count Corla. I'd like to thank you for the opportunity to speak on this very important issue, which, as previous speakers have stated, is one of the most divisive in Irish politics. That is perhaps why successive governments have done so little for 20 years. However, the fact that something is difficult is not a reason to do nothing. If that were the case, this august chamber would still be a lecture theatre of the Royal Dublin Society. Instead, it is the Parliament of a sovereign state. I greatly welcome the Minister for Health's commitment and that of the Minister for Justice to legislate in this area. I was 9 years of age when the 8th Amendment to the Constitution was made. I was 18 years old and about to become a law student when the Supreme Court decided the X case, which, as we all know, involved a girl of 14 years of age who had become pregnant as a result of rape and as a result was suicidal. In that case, the Chief Justice stated, and I want to reiterate that for the benefit of this House because there's been a lot of obfuscation on what exactly the X case stated. I therefore conclude that the proper test to be applied is that if it is established as a matter of probability that there is a real and substantial risk to the life, as distinct from the health of the mother, which can only be avoided by the termination of her pregnancy, such termination is permissible having regard to the true interpretation of Article 40.3.3 of the Constitution. Considering that a suicide risk had to be taken into account in reconciling the right to life of the mother and the unborn, the Chief Justice continued, I am therefore satisfied that on the evidence it has been established as a matter of probability that there is a real and substantial risk to the life of the mother by self-destruction, which can only be avoided by the termination of her pregnancies. Similar judgments were delivered by 3 of the other 4 judges, with Mr. Justice McCarthy noting very pertinently that the right of the girl here is a right to a life in being. The right of the unborn is to a life contingent on the survival in the womb until successfully delivered. On the facts of the case, he concluded that on the facts which are not in contest, I am wholly satisfied that a real and substantial risk that the girl might take her own life was established. It follows that she should not be prevented from having a medical termination. That same year, 1992, a proposed 12th Amendment, which would have excluded the threat of suicide from justifying an abortion, was defeated by the Irish people. 10 years have elapsed and nothing was done by this House. A further 10 years later, in 2002, the 25th Amendment to the Constitution Bill also proposed to remove the threat of suicide as a grounds for legal abortion. Again, that was rejected by the Irish people. And another 10 years have elapsed and this august chamber did nothing. Here we are, less than a week before the 2nd anniversary of the judgment of the European Court of Human Rights into A, B and C, discussing the report of the expert group set up to examine the judgment. That, Count Corla, is the legal context, or rather the absence of a legal context, in which the A, B and C case was decided. As a result of that, girls who were born in the same year as me, women who went to college in the same year as me, will have spent their entire lives subject to what is described in the European Court judgment as the chilling effect of the criminal law provisions in the 1861 Act, which impact upon both women and doctors during the medical consultation because of the risk of both parties of criminal conviction and imprisonment. The UN Special Rapporteur on Health and the UN Committee Against Torture have also commented upon the effect of criminal laws which impact upon the health of women. As Minister Shatter pointed out, when discussing Deputy Daly's bill, which he acknowledged was well-intentioned but was unfortunately substantially defective, her bill failed to adequately deal with sections 58 and 59 of the Offences Against the Person Act. In recent weeks, that Act has also, as alluded to in the European Court judgment, placed doctors in an impossible position. In recent weeks, I have heard claims from medical doctors who work in obstetrics, such as the Master of the National Maternity Hospital at Holles Street, who called for more guidance to help doctors to deal with the grey area arising in cases where there has been a risk to the mother's life, and a consultant to the emergency department of Dr. Plunkett, who called for legislation to clarify when doctors can intervene and terminate a pregnancy in a bid to protect the mother's life. Therefore, I welcome this government's commitment to bring forward legislation to bring clarity in that area. However, that, Count Corla, is not the end of successive governments' failure to legislate in this complex area. There are some in this House who have gone on the record as saying that marriage is primarily about children, its main purpose being to propagate. While I would disagree with them, I would point out to this House that there are many, and there are an increasing number of couples who find it very difficult to propagate, who find it very difficult to conceive a child, and as a result resort to IVF and assisted reproductive methods. Now, one of the undeniable consequences of that is an increase in the number of frozen embryos. Again, a matter that this House has failed to legislate for. In Roach versus Roach and others, that matter fell to the Supreme Court to decide whether a frozen embryo is human life within the meaning of 40.3.3. The Chief Justice of the time, Mr. Justice Murray, said, "I do not consider that it is for a court of law faced with the most divergent, if most learned views in the discourses available to it from the disciplines referred to pronounce on the truth of when precisely human life begins." It is important to recall that the European Court of Human Rights, in the A, B and C case, came to exactly the same conclusion, that there is no consensus in Europe as to when human life begins, and the protection for that human life, and indeed from the moment it begins, when it is decided, falls to member states to adjudicate. Yet this state has singularly failed to decide when human life begins and when the protection of human life begins in accordance with Article 40.3.3. Mr. Justice Hardiman, in the case, stated that the issue is all the more urgent. Mr. Justice Hardiman, firstly, in the case of Roche versus Roche, it's important to point out to the House that the Supreme Court decided that frozen embryos did not attract the protection of 40.3.3. Mr. Justice Hardiman stated that because the fact that difficulties are raised does not absolve the legislature from the obligation to consider the degree of respect due to fertilised embryos and to act upon such consideration by its laws, there has been a marked reluctance on the part of the legislature actually to legislate on these issues. The court simply draws attention to this. That is all it can do. That is what McCarthy J did in the 1992 X case, but Mr. Justice Hardiman pointed out that he did so apparently in vain in the X case 18 years ago, but the court does so as seriously and as urgently as it can. Finally, Count Corl, I wish to point to another anomaly in Irish law, and that is one which concerned the 2007 case of Miss D, a minor, which was also considered by the European Court in the A, B and C case. Miss D was a minor in HSE care who had been prevented from going abroad for an abortion. Her fetus had been diagnosed with anencephaly, a condition where a major part of the brain is missing, a diagnosis which was accepted as being incompatible with life outside the womb. The High Court clarified that the case was not about abortion or termination of pregnancy, but about the right to travel, admittedly for the purposes of a pregnancy termination. Count Corl, I happened to be in court on other business in the morning she applied to that court, and I still recall her standing towards the back of a very crowded courtroom full of bewigged and begowned barristers and solicitors as her medical details were read out to that crowded courtroom. I do not believe that in this republic, women with a medical condition such as hers should have to be dragged into court to outline the most intimate medical details to a crowded courtroom. The European Court of Human Rights referred to its case law where it had found, as I said, that there was no... the court considered that it was evident that travelling abroad for an abortion constituted a significant psychological burden on each applicant, but concluded that there had been no violation of the Convention as regards the first and second applicants. As I mentioned earlier, in general terms, the court affirmed that the court does not consider that the prohibition in Ireland of abortion for health and well-being reasons exceeds the margin of appreciation accorded in that respect to the Irish state. Nevertheless, Count Corla, I think it is high time that the Irish legislature decide what exactly constitutes the unborn who attract the protection of 40.3.3. Outside altogether from the A, B and C and X case, does it include frozen embryos? And if not, when will this legislature legislate for that? Does it include a fetus which is diagnosed with a condition which is incompatible with life outside the womb, or does it not? And for the avoidance of doubt, because I'm very clear that this issue is emotive, and every word that every politician says on this issue is likely to be skewed, I am not for a moment talking about diagnosis of an illness, diagnosis of a disability. I'm talking about a diagnosis where it is found that the fetus is incompatible with life. Does that fetus enjoy the protection of the right to life? Thank you for the time you have afforded me, Councillor Corley.